September last year, and we have hit the ground running. I'm going to read the statement, after which we will take one or two questions, and then will be shared with you a copy of the same. The Commission on Administrative Justice, or the Office of the Ombudsman, expresses deep concern over the judiciary's delay in the resolution of the complaints and petitions that are filed against the judicial staff and officers. As we speak, the Commission has received and forwarded over 700 cases of maladministration to the judiciary for the last 5 years. Out of those cases, nearly 60% remain unresolved, undermining the quest for justice for the aggrieved Kenyans. The complaints received by the Commission are documented in the status of administrative justice and access to information. This is the document that we have. Now, most of these complaints relates to the delay in the issuing of judgments, inefficiency, unresponsive official conduct, unlawful official conduct, manifest injustice, unfair treatment, abuse of power, and discourtesy. Some complaints raise serious issues such as fraudulent access to money from the judiciary's deposit account, fraudulent use of deposited security through doctored proceedings, solicitation of bribe, inordinate delay in delivering judgments, and delivering error judgments. The Commission therefore has requested for the status report on the complaints that have been simultaneously lodged with the Judicial Service Commission and the Office of the Judiciary Ombudsman. Some of the cases include: one is against magistrate. The allegation is that the magistrate fraudulently accessed funds from the judiciary deposit account. What is the status? The removal process for the said magistrate commenced in 2019, but remains unresolved 6 years later. The second one is abuse of power. The allegations is that the magistrate allegedly manipulated court proceedings and used a litigant's title deed as security without the knowledge and the consent and to release other accused persons in his case, in his court. It is instructive to note that that is not the only complaint. That conduct has been repeatedly done by the said judicial officer. Despite the seriousness of the allegations, the OJC has not concluded investigations or provided the outcome. The other magistrate is accused of alcoholism, soliciting bribes, and delaying court proceedings, with most of our court cases starting after 11 or at noon. This, again, the complaint was lodged with the Office of the Judiciary Ombudsman in 2024, and it remains unresolved, raising questions of inefficiency. The other one is contradicting or unclear way in which the cases have been handled about two magistrates. One was alleged to have delayed 30 judgments, and the other one over 250 judgments. There are some cases where judges have delayed over 100 judges. More than 4 years later, they are still in the office. In the first case, the accused magistrate who had delayed 30 judgments was dismissed, while the second one was accused of delaying over 250 judgments was acquitted. This raises serious questions about fairness, consistency in handling similar claims. There is need to have a standard way of dealing with similar offenses. The other accusation is of bribery, where a magistrate was accused of corruption in a traffic case involving two public service vehicle operators and were asked to pay a bribe. As we speak, the complaint remains unaddressed, highlighting the concerns about unlawful official conduct. We have a case involving a High Court judge who was accused of having a backlog of over 32 judgments and issuing error judgments. These are basically verbal ruling without written judgments, therefore making them inaccessible to litigants and advocates, not even in the CTS system. The case was lodged 3 years ago, and it remains unresolved, raising the issue of inefficiency. Finally, there is a complaint against a judge who upheld a lack of jurisdiction in a commercial case, but proceeded to award a counterclaim of 59 million in the same ruling. It is instructive to note that if you have no jurisdiction, then there's no way you can have jurisdiction to award in the counterclaim. That complaint still remains unaddressed despite the significant implication. Pursuant to our mandate under the Constitution, the Commission on Administrative Justice, under our Act, and as well as the Access to Information Act, the Commission on Administrative Justice has, via a letter dated 3rd February 2025, urged the Chief Justice, Honorable Martha Koome, to speedily and conclusively resolve the complaints against the judiciary. In addition, the Chief Justice has been urged to publish and publicize a status report on all such complaints report on all such complaints in fulfillment of the provisions of Article 35(3) of the Constitution and Section 5 of the Access to Information Act. The CAJ has further requested the Chief Justice to submit a compliance report on the status of such complaint to the Office of the Ombudsman within the next 21 days. The Commission action on its part is the continuous engagement between the Commission and the Judiciary and the JSC regarding matters falling within their respective mandate. This is anchored in the Constitution and the law and routinely carried out to address the issues of maladministration in the public sector and to enforce transparency, accountability in governance. Judiciary is one of the public institutions against which many complaints of maladministrations have been lodged with the Commission. The judiciary is the citadel of the rule of law and occupies a special place in the Kenyan's governance system. In this regard, while recognizing the independence of the judiciary, the Constitution enjoins the judiciary to be accountable to the public. In particular, Article 10 requires the judiciary, like any other state organ, to apply, promote national values and principles of governance, including good governance, integrity, transparency, and accountability. Similarly, Article 172 enjoins the JSC to, among others, promote and facilitate the accountability of judiciary. Efficient, effective, and transparent redress of complaints of maladministration against judges, judicial officers, staff is therefore a constitutional imperative. We are alive to the fact that there are provisions of Article 249(2) of the Constitution talks of the interdependence of Constitutional Commission and independent offices. That provision does not, however, exempt them from jurisdiction from each other. Their general roles, as stated in Article 249 of the Constitution, is to provide checks and balances, thereby protecting the sovereignty of Kenya and ensuring the compliance with the Constitution. To this end, matters relating to maladministration and access to information in the Judiciary and JSC are amenable to the jurisdiction of the Commission. To state otherwise would be tantamount to overthrowing the Constitution. The CAJ, therefore, urges the Judiciary to publish and publicize its decisions of the resolved complaints on its website and other available platforms. This would give meaning to Article 10, Article 35(3), Article 172, and Article 232(f) of the Constitution and the Access to Information Act. In the light of the above, the Commission urges the Chief Justice to comply with the directives outlined in its letter of 3rd February 2025. The Commission reiterates its commitment to redressing maladministration in the public sector and advancing open governance in Kenya. To this end, the Commission will continue to engage with the Judiciary and other stakeholders to fulfill their mandate effectively. The Commission calls to action underscore the importance of transparency, accountability, and efficiency in the Judiciary. The Commission looks forward to the continued cooperation with the Judiciary and remains committed to safeguarding the rights of Kenyans by ensuring that the complaints are promptly resolved and fairly. We urge all the Kenyans to continue raising complaints wherever they encounter service failures in the public sector, including the Judiciary, to ensure accountability of public officers. Now, we have the statistics, which I'm going to take you through before we take the questions. From where we are, out of the cases that we have forwarded to them, 43% have been resolved as a result of our interventions. 57% still remain unresolved. That gives a summary of the entire complaints received as 700. Now, the nature of complaints are varied. We have categorized them in delays. Again, that is a maladministration in terms of which squarely falls under our mandate. We have 449 cases. In terms of inefficiency, we have 91 cases. Manifest injustice, 52. Unresponsive conduct, 49. Unfair treatment, 32. Unofficial conduct, 6. Inaction and ineptitude follows in that order. In terms of the graphs, this is just representing what we have talked about. 62% of those cases involves delay. And that is totally unacceptable. But I'm glad that where the Commission has had an opportunity to intervene, the cases have been resolved. And the cases that we have shown has been resolved were as a result of the Commission taking up the matter with the respective Judiciary. With those, I want to thank you and invite 2 or 3 questions. Yes, sir.
Thank you so much, Chairman, for the presentation. Just 2 issues for me. The other commission, JSC, is also a commission on its own. Is it a case of interference in terms of second question is, how do you distinguish yourself as a commission from the ongoing, what I could call standoff we've seen, especially against a section of top lawyers led by senior counsels, let me say against the Chief Justice? How do you distinguish this very sincere call for accountability with the ongoing, I would say, politics within the judiciary with calls to have the Chief Justice resign?
Okay. Do I allow more questions before I take, or I take this one? Because I can answer that. As we have noted in our statement, we understand that the judiciary and JSC are independent. There's no doubt about it. What we are concerned with is the fact that there has been certain delays, which points to maladministration. For us, our mandate here is maladministration in public service, both at the national and the county level. At the national levels, all the institutions. Okay, sorry. As I was saying, the mandate of the commission is to deal with maladministration in the public sector, and judiciary is one of them. But we are only talking about the delays. The question is, why should a Kenyan complain to us when the ID is delayed, or the passport, and then when it comes to judiciary, delaying judgment for over 4 years, you tell us, oh, no, that's not our mandate. No, that is maladministration, and we will call judiciary to account for that. We are not fighting. There's no tough war here. We are simply saying, when it comes to two issues, maladministration and access to information, that is our mandate, and we shall enforce it. The second question that you have asked, we have seen, but we are not involved in any politics. We are simply stating, you can see the records that we have given you dates back to 2019, more than 5 years delay. I'm sure the politics did not start in 2019. So, and it is in our report. We have captured the delays, and at the same time, we have the success stories. The success stories is those ones where we intervened as a commission, and the judiciary acted and resolved those cases to our satisfaction. And that is why we are reporting that over 302 cases have successfully been reported. And therefore, we are not playing politics. We are not into politics. We are simply saying the judiciary ought to be accountable for the delays.